Hello, and welcome to Termly's weekly privacy news roundup. My name is Carolyn, and I am the Director of Global Privacy and Data Policy at Termly, and I would like to tell you about the top privacy news stories for this week relevant to your business.
The European Data Protection Board, or EDPB, has a new cookie banner task force. Following the influx of complaints about non-compliant cookie banners filed by NOYB, or None of Your Business, the European Data Protection Board, also known as the independent European body that contributes to consistent application of data protection rules throughout the EU, has established a cookie banner task force. The task force aims to get supervisory authorities across the EU on the same page. The task force will collaborate on legal analysis and possible infringement, provide support to manage responses to these complaints on a national level, and streamline communication in those efforts. The Interactive Advertising Bureau in Europe is cracking down on consent collection framework. The Interactive Advertising Bureau in Europe conducted reviews of website consent management systems. As a result, the IAB issued warning letters to approximately 10 companies that provide consent management solutions and temporarily suspended a couple of consent management platforms, CMPs. These platforms were suspended for non-compliance with the IAB's voluntary framework, TCF. IAB's TCF 1. Set standards for managing the flow of data tracking consent throughout the digital ad supply chain, and 2. Requires consent management platforms to present notices in a specific manner. Drop the mic. Italy's Data Protection Authority is turning its focus to apps accessing phone mics for ad purposes. Have you ever seen a targeted ad on your phone after having a conversation about that topic? This doesn't sit right with many, including Italy's Data Protection Authority. Italy's Data Protection Authority observed an increase in the number of apps that ask permission to use your microphone at the time of download. Many accept without even thinking about it further. Not much thought goes into what will be done with data collected from accessing your microphone. Because of this, Italy's DPA is launching an investigation looking at some of the most commonly downloaded apps that access users' microphones to collect and sell data without express consent. As part of this investigation, they're looking to verify that these apps are 1. Providing clear and transparent information, like in privacy policies and just-in-time notices, and 2. Getting free and informed consent. This investigation comes at the heels of work by this DPA, aiming to simplify the provision of information about data processing activities using symbols and images. Secure your revenue by securing your data. Singapore's PDPC issues fines for insufficient security of personal data. Singapore's Personal Data Protection Commission issued fines to 3 companies for violations of Singapore's Personal Data Protection Act for failure to implement reasonable security arrangements to protect personal data, resulting in unauthorized disclosure and ransomware attacks. Senmad Tech was fined $9,000 as a result of unauthorized access to data stored on AWS. SAP Asia was fined $13,500 when former employees' personal data was disclosed. Serious Keto was fined $8,000 as a result of a ransomware attack on its servers. French DPA's €3,000 fine emphasizes the importance of making the DSR process easy. France's DPA fined a joint stock company called New Company of the French Directory €3,000 following complaints of difficulties encountered when requesting erasure or rectification of personal data. CNIL had previously reviewed the company's practices following 16 complaints from data subjects. As a result of that review, CNIL had ordered the company to comply with GDPR within 2 months, but the company failed to do so. Norway's Data Protection Authority fines a toll company just over $500,000 for issues around the transfer of data to a data processor in China without adequate security or legal basis. This does not come entirely by surprise. The company received a notice of a fee of the same amount earlier this year. the DPA questioned whether the company has implemented appropriate technical and organizational measures to ensure adequate security for the information transferred. They also determined that the company had no legal basis for transferring the data to China. Italy and Ireland's DPA want Facebook to do more to ensure transparency with its newly released wearables. Following Italy's urging of Ireland's DPA to look into Facebook's new wearable technology, the Irish and Italian DPAs published a joint statement. The joint statement calls on Facebook to provide assurances that their newly released product sufficiently informs individuals when they're being recorded. The statement emphasized that the LED indicator light on the wearables might not be sufficient notice, and the mechanism does not seem to have been sufficiently tested. It is still unfamiliar to the public and less obvious when it is recording images. Finally, the statement urged Facebook to conduct further testing on the product and ensure public awareness of the new technology. Quebec leads the way for modern privacy legislation in Canada by adopting Bill 64. This new legislation aims to modernize legislative provisions for the protection of personal information. It will go into effect 1 year from adoption in September 2022. Key updates include clarification on consent requirements for the processing of personal information, establishing new data subject rights to access personal information, and increased potential fines for violations. Businesses can look out for additional information and tools from Quebec's Commission on Access to Information to help them comply with new obligations. The California Privacy Protection Agency kicks off preliminary information gathering for CPRA regulations. The California Privacy Protection Agency, or CPPA, seeks input from stakeholders in developing regulations to guide entities in complying with the CPRA. This is similar to how the CCPA has its own regulations. The agency is particularly interested in comments addressing new and undecided issues not covered by the CCPA regulations, including high-risk processing, cybersecurity audit and risk assessment requirements, automated decision-making, audits performed by the agency, consumer rights to delete, correct, and know, including information that must be provided in response to a request to know, consumer rights to opt out of selling or sharing their personal information and to limit the use and disclosure of their sensitive personal information. Finally, definitions and categories. The new European standard contractual clauses are in effect as of September 27th. Now, what does that even mean? New European Union standard contractual clauses are in effect as of September 27th. Now, what does that mean for you? Many businesses scrambled this September to update any data transfer agreements, including many data processing agreements with provisions about data transfers outside the EEA, relying on standard contractual clauses, or SCCs, for European transfers to meet the September 27th deadline. Going forward, all new agreements that rely on SCCs will need to have the new version of the SCCs to satisfy GDPR data transfer requirements. In an effort to help with the complexity, law firms have published resources to help businesses make these updates.
Check out Termly's resources to help protect your business. Termly, a global leader in data privacy solutions for businesses.